Okay, question on the state exam about something reasonably new, and it will be, he likes to do these newer questions. So, we have a law now that says if a mobile home park is being sold, the actual owners of the trailers in the park have a right of first refusal to buy the mobile home park. So, there's a question, yeah. So if you're selling your mobile home park, all the guys that are, have their trailers that where they're leasing, you know, their little pad, they have the right to, they have the whole community has the right of first refusal to buy the park. Okay, another question, who does not have to be licensed to negotiate loan modifications in Delaware?
I had to get 1 point of clarity. They have the right to buy out their piece of plot, even though it's not individually
No,
parcel?
the association.
Okay.
The association does. All right, so in Delaware, who does not have to be licensed to negotiate loan modifications? The exceptions are a real estate agent and an attorney. This is actually a question on the national exam, I lied, there is one question. What is the official datum of the USGS? New York Harbor. Mean high sea level of New York Harbor. Knowing that's gonna make you one hell of an agent. United States Geological Survey, USGS.
Question? What is it?
What is the official datum of the USGS? The mean high sea level of New York Harbor. No, I don't know why it's not that. This question comes up a lot. Where must you place your signs? And that's outside the clear zone. The clear zone is that 10-foot area from the edge of the paved road. Now, somebody got a question about bilateral and unilateral contracts, which is interesting. But a bilateral contract is a two-promise contract. The agreement of sale is a two-promise contract. I promise to pay you $100 grand for the property. I promise to sell you the property for $100 grand. Swap of promises. A unilateral contract is a one-promise contract. In real estate, the best example is an option contract. I give you the right to purchase this property for the first 5 years of this lease at $100,000. One promise in that option. A reward contract is another example of a unilateral contract. I promise to pay 10 grand to the person who supplies information leading to the arrest and conviction of the perpetrator. I got a usury question. Not sure what it was, but usury, we do have a usury law in Delaware. It's a law that says you can't charge more than this rate. We have something called the legal rate, and you can't charge more than the legal rate. Now, if Dave gets tricky, the legal rate in Delaware is 5% over the Federal Reserve discount rate. That's what the legal rate is. Now, if you think about it, you know, that's probably the Federal Reserve discount is 1. That would make the legal rate 6. How many people in here got credit cards that are greater than 6? You all better raise your hand. Okay. How do they charge more than that? That's just because it hardly applies to anything. There's federal laws that supersede the Delaware usury law, and then Delaware usury law has a whole bunch of carve-outs. Okay. Yes?
Just real quick, the option contract, you said it was unilateral, so is that unilateral with the buyer or something?
It's just a one-promise contract.
Okay.
So the property owner who owns it gives someone the right to purchase the property during a certain period of time at a certain set price.
Okay, so I think I saw that question. I wasn't sure which one it was.
All right, fair housing. Another fair housing question. Where in Delaware do you file a fair housing violation? That's a state human relations commission. Guarantee fund questions. Now, the guarantee fund is that fund that you guys pay into when you first get your license. That's been a question on the exam. How is the guarantee fund funded? It is funded by a one-time $25 payment that you pay at the time you first get your license. So it's a one-time $25 fee you pay when you first get your license. Another guarantee fund question is, what happens when the guarantee fund goes below $250,000? That's the minimum balance of the guarantee fund. At the next renewal, each licensee will pay a pro rata amount to bring the fund back to $250,000. So while you're writing that, I'll give you the example. The fund goes to zero. There's 250,000 licensees. At the next renewal, each will pay an extra dollar to bring that fund back to 250. And I did that math in my head, if you can believe that. It's amazing. All right. This probably is not going to be on a broker exam. What does it take to be a salesperson? But you take that 99-hour pre-licensing course. You got to pass the course, then take the two-part standardized test, which is the Pearson VUE test, the national and state, and you must do that within a year. I don't know why people wait longer than a year. Okay. So recently, I taught a pre-licensing class, and they had TRID questions. So we talked about those TRID questions. What does TRID stand for? Truth in lending is the T, TILA. Okay? The R is RESPA, the Real Estate Settlement Procedures Act. The I is integrated, and the D is disclosure. That's a question. It's a stupid question. What does TRID stand for? Who's most likely going to prepare the buyer's closing disclosure? The answer to that is the lender's most likely to do that. Who's most likely to prepare the seller's closing disclosure? And that's going to be the attorney's office, because it's a Delaware question. Let's see, what else? What two disclosures were integrated to create the loan estimate? The initial truth in lending and the good faith estimate. Those old documents were integrated together to create the loan estimate. This is all Greek to Chris.
I'm like, I have no idea what this stuff is. I've never seen any of this stuff.
You just don't see it. You get to see the nice old standard HUD.
So the loan estimate is a conjunction of what?
The initial truth in lending disclosure and the good faith estimate of closing costs.
Good faith estimate. Thanks.
Somebody got a littoral riparian question, which is weird and interesting. Littoral are those rights that you have by living next to a navigable waterway. I'll tell you a way to keep these straight in your head, okay? Riparian is those rights that you have by living adjacent to a non-navigable waterway. Littoral starts with L, lake. A lake is generally navigable, right? Riparian starts with R, river. A lot of rivers aren't navigable, right? So that's how I keep it straight. Now, the littoral question, the two questions I think that can go beyond what they are is your boundary lines. With littoral, in Delaware, which is different than most of the other states, with littoral, your boundary line is the mean low sea level, not sea level, what the hell am I saying? Tide, the mean low tides. So your boundary line is that average of low tides. And everywhere else on the planet, it's the average of the high tides. Delaware, it's the average of the low tides. That actually gives you a little more length, right? Riparian, by living next to a non-navigable waterway, river, you own to the center line of that water course. That's about all I think he can ask you about that. Send in some really great softball questions. Who pays the property taxes for the condo unit? That's gonna be the unit owner pays those, right? It's not gonna be the association or anything like that. So condo, the other condo questions are, what do you own? You own your unit in fee simple title, and you own a percentage interest in common elements with the other condo owners. That kind of co-ownership of those common elements is tenants in common. Some other condo questions. Now, bear in mind that sometimes, not often lately, but sometimes he'll invoke the Unit Property Act. That's a condo question. Under the Unit Property Act or with a unit property, and you'd be like, what the hell are you talking about? That's a condo question. So the question could be something to this effect. How is your percentage interest determined if you own a unit property? Well, he's just saying, how are the percentage interests determined if you own a condominium? The answer to that question is typically based on relative size. There's other ways you can do it, but most of the time it's relative size. You're basing your percentage interest on relative size. Bigger units have a higher percentage interest, smaller units have a lower percentage interest. That drives some of the other condo questions. Your voting rights, what are they based on? They're based, well, it's based on your percentage interest in common elements. So it's all weighted based on that. A larger unit has a larger voting block than a smaller unit. Your dues are paid based on what? Your percentage interest in common elements. So a larger unit pays more dues than smaller units. All right, well, let's go back and finish up some of these condo questions. Condo questions about insurance. I don't think they're all that difficult. Think about insurance as two components, liability and casualty, okay? So liability deals with somebody getting injured, casualty deals with damage to your property. So someone slips in the lobby of a condo building. What is that covered? That would be covered by the liability portion of the master condo policy. The HVAC unit that services all the condos, that gets damaged by weather. What is that covered by? Well, that's the casualty portion of the master policy. And then if someone gets injured within your unit, that's covered by your unit policy, the liability. If you are cooking and you blow up your kitchen, that'll be covered by your casualty portion of your unit policy. I think that's covered them all. There's an oldie, because it just popped into my brain. It hasn't been on in a long time, but the question is, can a tenant create unit properties? Now you're like, well, how could a tenant create a condo? He's just a tenant. Well, you may have heard of these things called ground leases. Under a ground lease, a tenant can create unit properties with the consent of the landlord. You guys have probably heard about the Medical Arts Pavilion down near Christiana Care. Those are condo units that were created by a Healy partnership that was the tenant that was constructing those buildings. Christiana Care held on to ownership of the land, but the Healy enterprise, they created those condos. Of course, they needed consent of Christiana Care. And Christiana Care is a nonprofit, right?
Yeah, whatever.
Yeah, nonprofit, my ass. My heart attack cost me 90 grand. Well, it cost my insurance carrier 90 grand. If you guys feel a little pressure in your chest, and you get the cold sweats, you're having a heart attack. Even if you work out all the time.
You're gonna give me a heart attack.
Well,
Math test today.
I was in the house by, this is a couple of years ago. I was in the house by myself. The kids were gone, Angela was gone, and I'm feeling like a little like pressure in my chest, and I got the cold sweats. So I type in my phone, they're like, you're having a heart attack, call 911 immediately, do not drive yourself, like in big letters, and so when I drove myself to Christiana Care, and I stopped at Wawa, not Wawa, yeah, Wawa on the way, off 7, and I got myself an aspirin, because they did say take an aspirin. I'm doing all kinds of dumbass shit. I'm having a heart attack, right? And then, they hooked me up, and they're like, I think you probably had indigestion or something. You gotta do this enzyme test. They do the enzyme test, and it came back negative, and I'm like, what the hell, you know? All this nervousness, you know? And then the cardiologist came in, he's like, you know, sometimes these enzymes show up late. Let's do one more test before I send you home. And sure enough, I had a little tiny heart attack. And then I went in for cardiocatheterization, which is a crapshoot. The crapshoot is, where are they gonna stick the catheter? Here or here? Well, I didn't have a choice. I got shaved in both areas though, because the doctor makes the choice, which is like horrible, but then it went through here, so. And while they were in there, and they don't put you under, they put you on fentanyl. And then you can see your heart on the monitor there as they inject the dye to see how much blockage. And then if you got blockage significant enough, while they're there, they'll just run the stent down the catheter and put the stent in. But the surreal thing about that whole thing was, when I got in there, the two attendees, I guess they were nurses, a guy and a lady, they're just yucking it up. Like, I'm gonna have like what I view as heart surgery, and they're telling jokes and having a great old time. Like, should be more serious here, you know? The two doctors that came in, I think one was like an internist, and the other one was the regular cardiologist. He comes in and flips on the radio, and he's blaring rock and roll music while they're trying to talk over the music. I'm like, turn it friggin' down! It's my heart you're playing around with. And so then they finally say, there's enough blockage, we probably should put a stent in. So they get to the point of the stents. So the young internist is like, yeah, okay, right place. And he's like, no, it needs to go down further. It needs to come down a little further. He goes, no, I think it's in a good spot. He goes, it needs to come down further. And I'm just sitting there, it needs to go down further, please. And then 20 minutes later, back to my room. Ed let the cat out of the bag and told the office I had a heart attack, so they weren't expecting me for, a week or 10 days. And I went to the doctor, I'm like, I feel amazing, like nothing happened. Can I go to work? He's like, well, could you give it a day? And I was like, yeah, sure. So I had lunch and then I went to work. I walked in the office and I was like, you just had a heart attack, what the hell are you doing here? I was like, any of you guys call out for colds? Okay. All right, I shouldn't be telling stories. All right, another question that's been new on the exam deals with what counties do not require staking for the survey. And that's Newcastle County. Kent, Sussex requires staking. Maximum amount of transfer tax is 4%.
You said the ground lease, the tenants can create a lease?
A tenant can create a condo with the consent of the landlord. It's kind of a weird condo because you've got the tenant actually conveying fee simple absolute title. But they allow that. All right, the reciprocal license question. Reciprocal licenses, you can be what you are. So if you're a broker in PA, you can get a reciprocal license to be a broker in Delaware. If you're the counterpart of an associate broker in PA, you can be that here in Delaware, and same with the same salesperson. The common thread to all of those is you have to be in good standing in your other jurisdiction. There are other requirements, but they're just so convoluted and long. So when they say, what is it? Which of the following is required to get a reciprocal license? You're going to circle to being in good standing. All right, tax ditch questions. How many up here have ever heard of the tax ditch? All right, the tax ditch is a district that has drainage ditches that are for the benefit of the property. So some properties, the actual ditch is physically on it. And other properties, they just benefit from it, but the ditch is kind of far away. It's designed to drain into the ditch. So the three questions that deal with tax ditches are, well, the potential questions is, it's a, what is it for? Well, a tax ditch could be, create an easement for maintenance, because there typically is easements around these ditches. So it could do that. That's probably the answer to the question. Now, the other thing is, it creates a district where you pay a special tax ditch tax to pay for the maintenance. I don't think that's the answer to the question. Because all these guys that get that question, the one common answer is it creates an easement for maintenance. So that should be the answer, okay? Now, the other question dealing with tax ditches is, where do you get information regarding tax ditches? There are three places. Recorder of Deeds, pretty darn obvious, right? Department of Natural Resources and Environmental Control, that's DNREC, right? DNREC. And the one that's not so obvious, which will be the answer to the question, is the Prothonotary. And you're going, Prothona what? It's the clerk of the Superior Court. They're called the Prothonotary, and they have information on tax ditches, because you have to actually create the tax ditch in the Superior Court, and then that information gets recorded at the recorder's office, and then also over to DNREC. So you'll get a bunch of weird questions or answers. Pick Prothonotary. Do not pick the public library. Do not pick the local justice of the peace court. It's going to be Prothonotary.
Any clue how to spell that word?
Prothonotary.
Thanks.
You guys remember John Sullivan, right? The real estate attorney? When I was a law clerk for him, I was in my second year, and I just started working there. And he goes, I need you to, it can be generic, because I'm going to use it as a template, but I need you to go prepare a writ of feri facies, and then we need to get that filed at the Prothonotary's office. I'm like, all right, I'll get right on that. And I'm like, holy crap. So I figured, we're filing at the Prothonotary's office, I might get some information about what the hell a writ of feri facies is. So I go down there, and the old office, when you walked in, right to the right was the judgment section. So I walked in the judgment section, and there was this lady, Jay. Jay is about 6'3", big lady. And she's looking at my face, she's like, oh my God, are you okay? And I'm like, I was just asked to prepare a writ of feri facies, we're gonna file at the Prothonotary, and I don't even know what she's like, well, you're in the Prothonotary's office, and it's an execution writ. So we process those in the judgment section, and I can get you a form. And I was like, oh my God, thanks. So she goes back, copies me a writ of feri facies, or request for a writ of feri. Actually, it was a precipice for writ of feri facies. So it's like, a precipice, what the hell is that? And a precipice is a directing the sheriff to go do whatever. And I was like, oh my God, great. So I prepare this damn thing, I turn it into John Sullivan, and what does he say? I didn't even think you could get it done. That was a joke. Keep that SOB. All right, telling too many stories, gotta stop. What obligates a seller to pay a commission? You gotta have a written brokerage agreement. A CIS must be made available at an open house, right?
CIS available on open house.
That's right, Chris, you don't do CISs.
Houses on vacant land?
We do brokers opens. But the clients aren't there.
Okay, so there's something about the Form 5403, which you probably have no idea what that is. It's primarily designed to find an out-of-state seller selling, when I say out-of-state, they reside out-of-state, they're selling property in Delaware. And that form is designed to get them to pay an income tax on the capital gain. They're supposed to segregate a portion of their proceeds to cover any capital gains tax they have. I don't know exact question, but it's that form that out-of-state sellers must complete, actually in-state sellers complete it too, but it's mostly designed to capture something where capital gains tax might be required to be paid.
It's Form 5541?
5403.
5403.
All right, the broker's license is revoked. What effect does that have on the underlying licensees employed by the broker? It automatically suspends them. If you are doing a promotional, if you're doing a promotion where you say, if I can't sell your house, I guarantee to buy it, what is required in the listing agreement, the sales price that you're willing to pay for it. Another question is, how much time do you have to close after the listing is terminated? The answer is 60 days. Where must your agent's sale signs be placed? Outside the clear zone, we know that one. So let's talk about some deed questions now. What is the primary way that what's the primary legal description used in a deed in Delaware? The answer is meets and bounds. What is the typical deed in Delaware? That's the answer to that one is special warranty deed. And then some other warranty deed questions. They used to be sort of straightforward. What deed provides the most protection to a buyer? And that was general warranty deed because that gave the most level of warranties, the longest period of time of warranties covered. Because it was not only limited to the owner's period of time, but it covered all prior periods. So that was getting too easy. People were getting it right, so the question got reformulated to make it a little more awkward. What deed exposes the seller to the greatest amount of liability?
The seller. Okay.
No.
It's a
The
general
highest
warranty
level of
deed.
warranties exposes you to the highest level of liability, so it's the general warranty deed. See how awkward that is?
Yeah.
It's really awkward. And then the other straightforward thing dealt with a quitclaim deed. What deed provides the buyer with the least amount of protection? And that was a quitclaim deed, because there's no warranties at all, not implied, not expressed. So now comes the awkward question. What deed exposes the seller to the least amount of liability? Well, that's the deed that has no warranties. And that, again, is the quitclaim deed. Isn't that awkward as hell?
But you asked it differently. You said, what type of deed is used to remove a cloud from a deed?
That's not gonna be on the state exam.
Oh, okay, all right.
But removing a cloud on title, you use a quitclaim deed because there's no
Yes.
warranties.
Right.
You're having a dispute with somebody who claims they
Right.
don't have an interest, and you think they do. They don't wanna give you warranties, so you'd use the quitclaim deed. All right, some transfer tax questions. Question, mother transfers property to child. Who pays the transfer tax? The transfer tax is exempt, okay? Grandparent, grandchild transfer tax question. Transfer between grandfather and grandchild, it is not exempt. Now, the old answer was half by grandfather, half by grandchild. Everybody getting that right? They get it right because I'm telling you a damn answer, right? The answer now is the transfer tax are fully paid. That just simply means it's not exempt.
So why is it? It's a generation skipping thing? Is that why they do that?
I don't know, because I think it's exempt in PA. It's easily gotten around if mom and dad are still around, the mom and dad to the grandchild, because what you do is you have grandparent transfer to their child, and then their child transfer it to their child, who's the grandchild. But if mom and dad are not around, you're not gonna get around it, you'll be paying a transfer tax. There's a transfer tax exemption between parent parent and child, we talked about that, and spouse of child. Now, Dave could get tricky and say, parent transfers to husband of their child. That's exempt transaction, because that's a spouse of child. Parent transfers to both their child and the child's spouse, that's fully exempt as well.
What about widow of child?
Well, okay,
He's dead.
It's still spouse and child, right?
well, why would you transfer to a widow of
I
child?
don't know.
The person's
And
dead.
they were laughing. I don't know.
I mean, they might have kids together, you know,
I just wondered.
This is an
Think of her
interesting
as like a
question.
daughter, I don't know.
What was added to the Fair Housing in 1988? The Americans with Disabilities Act. There's an environmental hazard question, why might you do some kind of environmental investigation? And the answer
I'm
is,
sorry, what was the previous one, 1988, what happened?
they added the ADA, the Americans with
Added
Disabilities Act.
88, okay, thanks.
So this environmental hazard question, why might you do some sort of test, is where you see a stain around an underground storage tank. That's the one you're gonna pick, that's a pretty obvious one. That one, I don't think you get wrong. Some interesting disclosure questions. So, this one I think everybody kind of knows. So the seller disclosure does not disclose, it basically says that there's no water in the basement, right? You go after a rainstorm, you're the agent for the seller, and there's water in the basement. What must you do? And you'll circle, you must advise the seller to update the seller disclosure. That's the answer to the question. And then there's this awkward one that deals with disclosure of a defect that's discovered later, but it's in the context of commercial property. Believe it or not, there's not a clear-cut case in Delaware, so I don't know where the hell he's pulling the answer to this question from, because there really isn't any kind of bright line thing. But the key facts of the question were that something off-site was discovered by the buyer by the seller or seller's agent. Like they discovered there's gonna be a highway that's going to be built in close proximity to the property that's being sold. And so in that situation, you don't have to disclose that. You don't have to, by not disclosing it, the seller's agent has done absolutely nothing wrong. Now, the two key facts of that are, it's a commercial property and it's an off-site condition. Chris knows all about the due diligence. That's what due diligence is for, figure out all the crap. And that's not, since it's not on property, it's technically not something that they would disclose. You could maybe make an argument that knowing of groundwater contamination near the place, like it's next to a dry cleaner, there's ethylene all over the place, maybe that gets disclosed. But the answer to that question is, it doesn't need to be disclosed. Right, continuing education, I think you as brokers would get very straightforward questions, like what is your continuing education requirement? It's 21 hours every 2 years. Now, when they're referring to something every 2 years, often the answer is not every 2 years, but biannually. So know that biannually means every 2 years. Now, I doubt they'll do this because it doesn't make any damn sense, but there's been a continuing education question dealing with a new licensee. What is their continuing education requirement? And they must have 12 hours during their first 12 months of licensure. There's a question about, it has to do with environmentally contaminated property that's being redeveloped. And so we talk about this, the program's called the Brownfields Program. So if you get a question about environmental property that's being cleaned up to be developed, that's the Brownsfield Program. Do not circle Greensfield, do not circle Backfield, and do not circle Brownfield. I mean, circle Brownfield, what the hell am I saying?
Nobody say circle?
Circle the Brownfield. All right. Who doesn't have to have a license? The answer to that question is an auctioneer. Talked about that one already. I think the tax case question is if it establishes an easement for maintenance. Let's talk about seller disclosure questions. You don't have to do a radon disclosure when you're selling undeveloped land. There's a question about the seller disclosure, which of the following you don't have to give a seller disclosure for. The exemptions are foreclosure. You're not getting a disclosure from the sheriff. Another exemption is the executor is selling the property. What is not exempt is inherited property. Now, I'll explain the difference. When you inherit property, there's a specific devising that property to you under the will. So it says, I give 123 Main Street to Bob, Carol, and Ted. Then, as soon as that dude dies, Bob, Carol, and Ted are deemed the owner. The executor is not the person who sells that property. They are owners and they are required to give a disclosure. So heirs under an estate must give a disclosure. An executor, if you got a specific request of the testator to sell property and divide proceeds. So I direct you, executor, to sell this property and divide the proceeds between Bob, Carol, and Ted, then that's the proper party, the executor. So executors don't give disclosures, heirs do, sheriff in a foreclosure does not give a disclosure. The notice rule is an interesting rule, and I think you guys know this. When we had statutory agency, now Chris, you don't do that either, right?
No, we do statutory.
Oh, you do statutory,
Yeah.
okay, good. So you know with statutory agency, you're an independent contractor with statutory duties. With statutory agency, they threw out imputed knowledge, which was common law agency. Imputed knowledge means that what the agent knew, the principal knew, and vice versa. So when they wanted to get rid of it, they realized that creates a problem for notice. So the code says, with respect to notice, notice to the agent working for the client is notice to the client. So in other words, Adam Acosta is working with a client, right? Let's assume Jamie is his broker, right? You have to give Adam notice of the repairs that you want. It's in the very, very last day. And you're like, I don't know Adam's email, and it's 11:45. I know Jamie's email, and I will send it to Jamie. Well, notice to Jamie is not the agent working for the client. That will not be deemed notice to the client. Now, under all this common law crap that they threw out the window, you could make an argument that notice to Jamie would be notice to the client because it's working for the same employee, or not employee, but same broker organization. But the law is very clear. It's got to be notice from the agent working for the client. Notice to that agent is notice to the client, but notice to anybody else, like the broker, is not notice to the client. Now, I'll just throw this out there. There's a lot of admins that do a lot of stuff. they're not agents, right? And the agent does not want to be bothered once the contract's done. You deal with my admin, you send all the notices of repairs, well, be careful of that. Because sending notice to just the admin is not sending notice to the client under the code. You should send them to both, and then when you get the little pissygram back, you just say, you know, F you under your breath. That's cool. Another exemption for that disclosure is transfers between family members. There's no disclosure done. All right, I would take, because I don't know the question, they said, we got a question about the internet and World Wide Web. The only section of the licensing act that deals with that is section 2928. I don't know what the question is. All right, you're working with a boyfriend and girlfriend. And they ask you, what do you recommend the form of co-ownership we should acquire this property in? Well, the answer to that question is you must refer them to an attorney. You can't tell them, even though you could probably tell them, even, you know, with what you've learned and all the experience you have. The good news is these are a lot of questions that are duplicated. That means you're getting all the stuff you need. Yeah, I'm almost certain that tax ditch question is it creates an easement for maintenance. Married couple purchasing property, and they inquire about what kind of tenancy, you just must refer them to seek advice of counsel. That means you tell them to call me, right? Okay. New Jersey salesperson wants to show a warehouse in Delaware, what must he do? You might be leaning towards reciprocal license, but he can associate himself with a Delaware licensee to do that. They make it a little easier these days. Who doesn't have to have a license, an auctioneer. Pick that one. What must a tenant provide to the landlord when the lease has expired or is terminated? And the answer is must provide a forwarding address in writing. Here's some advice. Print and save all handouts that Roger gave you. They help a lot. They had that condo question, what's not included in the condo resale certification, the number of units being leased or rented. That was in 2016. The answer now is the number of units that are non-owner occupied.
But I mean, that can pose problems with financing. So how does the bank find out whether there's over 50% tenant,
They asked the condo.
but the condo's still required to tell them, but not required to put in?
How do you guys deal with that issue?
I mean, the owner still has to pay the condo fee, even if they're renting it out.
Right, absolutely. So how would they know?
When you go over, what Chris is driving at, and I hope all of you know this, is when you reach over a certain percentage of condos that are leased, and they keep tinkering around with that percentage, I don't know what it is right now, that they don't qualify for Fannie Mae loans and stuff. And also it has some effect on FHA stuff too, but I don't know how that physically happens.
I think they have a list, like FHA has a list of the condos that, because a lot of times you'll see it advertised as won't qualify for FHA. I think like FHA has a database, I believe.
Alrighty. The question about inspectors now are licensed. To perform a valid home inspection in Delaware, you must be licensed by the Delaware Board of Home Inspectors. You are a licensee, your license has been revoked. How long do you have to apply for reinstatement? You can do that every 2 years. It's kind of like the Pete Rose lifetime ban. He gets to apply every 2 years.
So if it's suspended, you said?
Revoked.
Revoked, oh
Yep.
gosh.
Another question about it is, you have failed to renew your license and 5 months have gone by. What must you do? You must pay the, delinquency fee, pay the delinquency fee. After 6 months, I think you gotta retake the state exam to pass it. And then if it goes past a certain amount of time, I think you gotta do the whole thing all over again, but the question was, up to 5 months, do you just pay the delinquency fee? The age of majority in Delaware is 18, so that's, if you're under 18, you don't have the capacity to contract. We were talking about that one. There's a question on the exam that talks about due diligence and what is a due diligence period. I didn't get any answer choices, but a due diligence period typically is a provision in an agreement that allows the buyer to do inspections, investigations, and at the conclusion of the due diligence period, they can terminate the agreement.
Prior to the end of the,
Well, you have to do it before the end of the due diligence. Don't wait till after. You got handling deposits, you guys know all about this. Licensee gets a deposit, what is he supposed to do? Give it to his broker immediately? How long does the broker have to deposit it? 3 business days. Yeah, this environmental contamination test, nobody, nobody would get this wrong. What conditions would require an environmental contamination test? Property with discolored soil and smell around an underground storage tank. That one's an easy one, that's a softball question, which is unusual. All right, let's talk about the infamous lake question. So, guy owns 2 parcels adjacent to a lake. He sells both parcels. What is the best way for him to reserve to himself a right to cross the parcels to get to the lake? Now, he's sold both those parcels. So he can't create an appurtenant easement because he doesn't own a parcel that can benefit it from it. So he can't create an appurtenant easement. Your other choices would be easement and gross and license, and I forget what the other one is. Well, a license is a personal right to use someone's property. That would work. But the question was, what's the best way?
easement and growth.
And that's an easement and gross, because that tends to be perpetual and non-revocable. That's the best for him. So, now, if you understand that's the answer to the question, that's great. If you don't, when you get the lake question, look for gross and circle the damn answer and get it. Because who gives a shit if you know why it's not? Okay. All right.
And we're done.
Here's an old landlord-tenant question. Oh God, I can't believe I'm now losing my voice. If the lease encroachment is best shown by a survey. Let's talk about this question, it's kind of odd. So, husband and wife, this is the facts. The husband and wife owns property as tenants in common. That's kind of unusual, because they normally would want to hold it as tenants by entities, but that's the facts. They own it as tenants in common. Husband dies and wife is survived, husband dies survived by his wife and 2 adult children, okay? Who signs the listing agreement? Well, it's a very fine point of Delaware's intestate succession law. It's something weird it does, which you guys shouldn't, and a lot of attorneys don't know. What it gives, well, here's the ownership. So tenants in common. She doesn't have a right of survivorship because it's tenants in common, so she doesn't have a right of survivorship to her husband's half interest. So she just owns her half interest. The husband's half interest passes under the intestate succession law because he died without a will. I don't know if I said that, but he died without a will, survived by his wife and 2 adult children. So intestate succession with respect to real estate says surviving spouse gets a life estate in this half interest, and the children have remainder interest. So who signs the listing? It's the wife and the 2 adult children, because the question basically is who owns the property. Most people just circle wife, but that's not the right answer. It's the wife and 2 adult children. It's the same as the lay question. If you understand why it's the answer, great. If you don't, who gives a shit? Get it right. All right. Let's talk about another life estate question. These are the facts, because 3 people can't have the same set of facts. That's too coincidental. So father transfers a farm, I don't know why it's a farm, but he transfers a farm to his son, giving him a life estate in the farm. So son owns it for his life. He's the measuring life. The son then transfers his life estate to a farmer. Now, think about it this way. The son can only transfer what he has. Ownership measured by his life. So really the only person we care about dying is the son, okay? Because if the farmer dies and son's still alive, the farmer's heirs still have a life estate measured by son's life. If the father dies, that doesn't affect the life estate either. So when son dies, that property reverts back to father. That's the answer to the question. When son dies, the property reverts back to father, because the farmer only owns it for the life measured by the life of the son, okay? All right. In a condo, you own fee simple title to your space, and a percentage interest in the common elements. You knew that one already. Highest interest in real estate recognized by law is fee simple absolute. Who is allowed to attend a condo meeting? I mean, that's condo owners. That's kind of interesting.
Yes, they don't know. Tenants can, sometimes tenants will stay in the building.
Yeah. Why did that? How long do you keep your continuing education certificates? 2 years?
Cheap certificate, 2 years.
Yep.
Did you really?
There's a radon question. What is radon? It's a radioactive substance that can cause cancer, right?
Right on, causes cancer. Yeah, exactly. Oh my gosh. You guys have made your test today, so.
Oh, another guarantee fund question. If there's been a payment payment out of the guarantee fund, what can happen to the licensee that was responsible? He can be suspended and ineligible to receive a new certificate until he repays the money plus interest.
Wow.
What does someone have to do in order to be paid again out of the guarantee fund?
Oh, there's a whole bunch of stuff.
Well, I guess, do they have to have a court order, do you have?
You have to get a judgment first.
Okay.
You then have to make an application to the commission and prove a whole bunch of stuff, that you got a judgment.
That you've exhausted all your means of.
You've exhausted all your means of collecting on that judgment. Proper notice was given to the commission so they could intervene in the underlying civil action. What else is there? Oh, and the licensee who caused the issue, the person who's trying to claim money out of the guarantee fund can't be married to that licensee, can't be a spouse, for obvious reasons. All right, so. Oh, some other easy ones. Actually, they're making this a little harder now. They used to ask us a very simple question, who was on the commission? And it's 9 members, 5 professional and 4 public. So if you're having trouble figuring out, well, how many professional, how many public, you want that commission to be swayed in favor of the professional. So that's why it's 5 professional, 4 public. They have asked questions about the makeup of these 5 professional members. I don't know this off the top of my head, but I think you've got to have, you gotta have three brokers from each county, associate broker from any of the counties? I forget, I don't know it off the top of my head. It is in your book.
It's in the book.
One from the city of Wilmington.
It's probably in the very first page.
3 brokers, 1 from each county, 1 associate broker, and 1 from the city of Wilmington, right?
Yeah, look, why don't you,
It says 3 licensed brokers, 1 from each county, 1 associate broker with 5 years' experience, 1 licensed salesperson with 4 years' experience.
okay.
No city of
Where's the
Wilmington?
city of
No,
Wilmington?
it's those are the public members.
The
One from
public
each,
member
one
ones
from each, and then
Right.
one.
Right, okay.
Yeah.
Oh, okay, the public members are the.
One from each county and 1 from the city of Wilmington.
Yeah.
Thank you.
They've asked some questions, and I don't think, I just think this is too easy for you guys, but they asked some questions about the module system. And, you know, there's 7 modules, we're talking about continuing it. So there's 7 modules, each module is 3 hours, each module is a specific subject, and, you know, you gotta take something, one of those modules. Module 7 is like your elective module. Just so you know, modules are, a course provider provides to the commission his outline of the seminar. He indicates what he thinks, what module it should fit in. And then commission agrees, then you're approved to teach that module. If they disagree, they might just assign it a module and tell you. So that's kind of how it works. I think you guys know that anyway. Installment sales contract question. Installment sales contract is a form of owner financing, seller financing. It is a form of seller financing where the buyer is paying off the purchase price in installments. He doesn't get the deed until he does that. The question is, what is the redemption period when the buyer defaults under that installment sales contract? Redemption period is 120 days. Just so you know, it only applies to residential installment contracts. So, under the old installment contracts, if you defaulted in your payment, you forfeited all the prior payments towards the purchase price, and you had to get the hell out. Now, you get 120 days to go find the money to pay the balance of the purchase price plus any arrearages. It does some other awkward things in statute. Once there's a failure to redeem, it turns everything into a landlord-tenant relationship. It lowers the monthly payment by 25%. I don't know why, it just does. And to the extent that you paid a deposit towards the purchase price that now exceeds 1 month's rent, you gotta refund that non-refundable deposit because it got turned into a lease. So I don't know why the hell anybody would ever do an installment contract in a residential situation. Who determines how a deed is recorded? That's a state law thing, state agencies. There's nothing federal about how you record, why you record, that's all state law. So don't pick federal agencies, Congress, the US Supreme Court, Donald Trump, don't pick that. This is kind of the reverse of something we talked about. So we talked about the broker's license being revoked and what effect it has on employed licensees that automatically suspends their license. What effect does the suspension of the salesperson or the revocation of the salesperson's license have on the broker's license? The answer is none, unless that broker had guilty knowledge. That just means knew something was up and didn't do anything about it. Title insurance questions. You guys all probably should know this. The lender's title insurance affords zero protection to the buyer, none. It only protects the lender. Vice versa, the owner's title insurance provides no protection to the lender. If a buyer gets title insurance, what does it not protect against? Well, it does protect against forgery. It does protect against zoning. It does protect against unpermitted items. So if you force removal because something's not properly permitted. What it does not protect, this is the answer, items a buyer was aware of that were on the title policy. That's so easy.
What was it again?
All right. What's not protected is items that the buyer was made aware of that showed on the title policy. Again, you must provide the CIS at an open house. Talked about that one. Talked about that one. Okay.
Well, ask a question, back to the broker. If a salesperson, license or has a charge or case or judgment put against them, does the commission notify their office?
I'm not sure I'm understanding how they get a charge. You mean,
Well, something, if they have, the reason I'm asking is because it was on the test, a state test, and it said if a salesperson has a charge or a violation or.
are you talking about a criminal charge, or are you talking
I believe,
about?
yes, I
Like a
think,
DUI or something like that?
yes.
Well, look, they're not gonna put that on the broker. The broker is not, when you renew your license, you are required to disclose crimes that you've been convicted of. So I'm pretty sure the broker doesn't police that. Do your brokers review your renewal application? Right? So that would be on you guys to be truthful, not on the broker. When must the CIS be provided? It should be provided to the consumer no later than the first scheduled appointment or showing of a property. The infamous lake question, the answer is easement and gross.
So you guys actually, like, people walk in and you're like, here it is. No?
Everybody does that.
Have a
Not exactly.
stacks. I've stacked so many.
Before they even knock on the door.
Yeah, right.
Another
Rubbing it in their face.
Another fair housing question is, how long does an individual have to file a discriminatory suit under the Fair Housing Act? And that's 1 year from the alleged discriminatory housing practice. I don't really share this answer, but RESPA primarily requires the timely disclosure of settlement costs. It's a lot more than that, but that's fine. Boy, that's an old one. I'm gonna say it anyway. In Delaware, when property is owned by spouses as tenants by the entireties, that's what's called ownership in severalty. Severalty means ownership by one. Now you're probably thinking, husband and wife, dude, what's up with your math? That's two people. But they view ownership by the tenants by the entireties is like ownership by a single marital entity, much like a corporation, where the spouses are like shareholders of the corporation. So ownership in tenants by the entireties in Delaware is considered ownership in severalty, which is not co-ownership, but actually ownership by a single entity. Little different version of this: father gives son a life estate. The son passes. What is the father's interest in that property? He has fee simple title. Property reverts back to him, and he has fee simple title.
What happens in a scenario when the father passes, then the son, he's got a life estate?
It's a real estate interest, and it'll pass under his will. So if he's leaving it to other children or beneficiaries, then when that son dies, it'll pass to those beneficiaries.
So whoever, does it have to be his children, or I mean like?
It's, I have a will and I leave it to my friend Chris, it'll go to Chris. So it doesn't have to go to children. If he dies without a will, then the intestate succession law will kick in, and it'll mean relatives pretty much.
But his life estate, that's all, he can only will the same, is that correct?
Well, he's not gonna probably will a life estate, he's probably gonna say, it's probably gonna have a residuary clause that says all my, whatever interests that have not been already devised under the will, I leave those interests, including interests in real estate, to the following. So it'll probably pass under what's called the residuary clause, the sort of catch-all clause.
So when you give property in a will, that's a devise?
Yes.
And then when you give personal property, it is a benefit?
It's a bequest.
Bequest.
They actually, hyper-technically, a bequest is a gift of tangible personal property, and a legacy is generally a gift of
Stocks.
intangible personal property, like stocks and things like that. But if you read wills, even by the most seasoned estate planning guys, you'll see clauses like, I devise, bequeath, unto so-and-so my gun collection. Well, that's not you shouldn't use the word devise,
That's a
because
bequest.
that's personal property, it should be, but nobody, cares. I did tell you an hour and a half, right?
Yep. 9 minutes.
I'll give you the full 9 there.
I'm ready. Stick a fork in me.
You didn't even have a test today.
I know. I had to deal with transactions falling apart left and right.
Should've came and took the math test.
Yeah, you're right.
All right, I'm gonna give this has not been on the test in a very long time. The question has to do with how long either a subcontractor or general contractor has to file a mechanics lien. A subcontractor has 120 days from when they last did work or supplied material. A general contractor has 180 days. Now, the old question tried to get you to think that a general contractor was actually a sub. Don't think just because of the type of job they're doing that automatically makes them a sub. You have to look at who hired them. If the owner of the property hires that person to work on the project directly, that person is not a sub, he is a general contractor. A subcontractor is someone hired by a general contractor. Notice I didn't say the general contractor, because you can have a lot of general contractors. Those are people hired directly by the owner. So, you're having this project done, and it's now bogged down because the tile mechanic that was the sub that was gonna do the work is off on another job. And you're like, well, I know a tile mechanic, I'll just hire my own guy to finish the tile work. That tile mechanic is a general contractor. You hired him, and if you stiff him, he has 180 days to file his mechanics lien. That's been the only question about mechanics lien. All right, so we're 3 minutes early. So you're all done.